Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm very happy that you're here, and I hope today will be the day I earn that subscription. For this evening content, we are covering a new motion to dismiss from the Laundries against the Petitos. As you will remember, Brian Laundrie was cause celeb there for a hot minute because he murdered his fiancée, Petito. And, you know, it was a thing, and people were sad about the thing, and they found her, they found him. He harmed him, he ended himself, and so forth and so on. But, of course, this is America, so the principles being dead is not necessarily the end of the thing. No, let's sue. So the Petitos want to sue the Laundries because their kid was murdered by their kid, right? So yeah, and they want to say that the Laundrie's parent had some sort of culpability in this somewhere. Now, we covered the complaint, we covered the lawsuit, and at least I thought it was pretty crap. It was pretty crap. It was alleging intentional infliction of emotional distress. But then it was saying that they didn't do anything. See, this was the problem, they said. The problem, they said, was they didn't do anything. They seemed to think that Laundrie's parents knew the truth about Petito, that she was dead, that Laundrie, the child, had killed her, where the body was, and some other details, right? They thought that they knew all these things. But you see, the thing is, the Laundrie's parents didn't do anything. They clammed up. They kept their damn mouth shut on behalf of their kid or behalf of themselves, either way. And so it's kind of hard to get to intentional infliction of emotional distress by the not doing things. That's tough. It's like, how do you get to intentional infliction when I didn't intentionally do anything? You can get to, you're trying to get there from failure to act. And you can't get there from failure to act because they have no duty to you, right? They have no duty to you. So you can't get there from failure to act. It's not like they had some sort of legal obligation to perform, and by failure to perform, that makes an overt act. No, they just didn't do anything. So it doesn't make sense. And so they filed to dismiss, which, you know, I would think. So let's read this and see what they're saying about the whole thing. And, we'll go from there, and let's get started with this. As I rearrange things on the screen so I can see everything I'm trying to do at the same time. Great. All right, the motion to dismiss. Let's just skip to the background. The facts concerning this case have received widespread media attention, and the court is likely, at least generally, aware of the events that precede the filing of this lawsuit. Reasonable. I mean, it was a hot story there for a minute. The complaint alleges that the plaintiff's daughter, Gabby Petito, and the defendant's son, Brian Laundrie, were engaged to be married. Miss Petito and Laundrie were traveling the western United States in the summer of 2021. At some point during the trip, Miss Petito went missing, and there was a search for her whereabouts. Shortly thereafter, law enforcement commenced an investigation, which included Brian Laundrie and the defendants. The complaint does not allege when Miss Petito was reported missing, or when law enforcement investigation of Laundrie's began, not that they would know, incidentally. But news reports indicate Ms. Schmidt reported Petito missing to the Suffolk County, New York Police Department on September 11th of 2021. Ms. Petito was found dead in Wyoming on September 19th of 2021. Brian Laundrie was found deceased in Florida on October the 20th, 2021 of suspected self-harm. Okay. The complaint should be dismissed with prejudice, and the plaintiff should not be granted leave to amend. I tend to agree. I mean, there is no possible theory of a lawsuit here. They didn't do anything. Although leave to amend shall be given freely when justice requires, leave to amend not be given where it be futile. It feels futile here. A proposed amendment is futile if insufficiently pled or is insufficient as a matter of law. The complaint is insufficient and deficient as a matter of law for many reasons, and these deficiencies cannot be cured. I tend to agree. The gravamen of the claimed wrongdoing is the Laundrie's exercise their constitutional rights and essentially made no statements to plaintiffs or law enforcement. As a matter of law, their silence could not form the basis of a claim for intentional infliction of emotional distress. Yep, that seems completely right. That seems completely correct. I have no duty to you. My failure to do things cannot form the basis of a tort or other wrongdoing unless I have some sort of duty or obligation to you. I have no particular duty or obligation. No matter what knowledge I have, no matter what ability I have, no matter what is available to me, if I have no duty, it doesn't matter, right? I can know that wrongdoing is happening. I can be in a position to fix it. I can be in a position to fix it with no cost to me or no harm to me, no sweat off my brow, right? I just have to speak the word, as it were, and your problem would end. I am not obligated to speak the word. It would be really nice of me to speak the word, since it costs me nothing and it would solve your problem. But in the absence of doing something, I don't have to speak the word. It can't form the basis of an intentional infliction. It doesn't make any sense from first principles. I have no obligation to you. And as we've pointed out, this can get even more extreme. We can get even more extreme with this, right? To at least my favorite example of the principle of this, right? I come along, you are in a pond somewhere in the world, not on my property, since someone, raised that problem last time. You're in a pond just kind of in the world, and I come upon you, and you are drowning in the pond. And I don't even have to get into the pond. All I have to do is throw you a flotation device, which is conveniently located at the pier. I mean, I could just do it, no problem, just throw the flotation into the pond, and you would get it, and you would not drown. Man, it would be really nice for me to throw that flotation device into the pond now, wouldn't it? Do I have to throw the thing in there? Nope. As long as I'm not doing anything, I have no obligation. So whatever my moral failings might be in this scenario, my legal failings, no. Just no. Just all the no. The Laundrie's constitutional rights and the elements for necessity for such cause of action would not change with an amendment of the complaint. Yeah. Their amendment right, their constitutional rights are a little bit neither here nor there. AD says, I'm a paramedic, have a duty to act. Police have a duty to protect or act. Aha. No, they don't, at least generally speaking. And I couldn't speak for you for sure, but generally speaking, probably you don't either. The police have no particular affirmative duty to act. Neither does anyone else, for that matter. To the best of my knowledge, a doctor doesn't have an affirmative duty to act. A nurse doesn't have an affirmative duty to act. Now, if they're on the clock, like in a hospital, but even then, it would be a violation of their contract. It wouldn't be a tort to you, right? So even I can't imagine that this is true for a paramedic, that you have some particular duty to act. Now, once you undertake action to rescue, you might have an obligation to follow that through. And incidentally, that would go true to my example of the coming upon you in it, and coming upon you in the lake, right? Once I take some action towards you, I might have some obligation at that point to follow through and complete my action. But I don't have the obligation to take the action in the first place. And it can't possibly be true for a paramedic. It can't possibly be true that you as a paramedic have an affirmative obligation to every person you see, who you come across, who is suffering distress, and you could solve the distress, and you, by your license, have some affirmative duty to act. It can't possibly be correct that you have an obligation, right? If you are called upon by your employer, if you're, once you undertake the rescue, maybe, but a doctor doesn't have an affirmative duty act, a nurse doesn't have an affirmative duty act, a paramedic doesn't have an affirmative duty act, the police sure as hell don't have affirmative duties to act. In the absence of some sort of obligation to you, I'm pretty sure you as a paramedic can just be, well, like that's nice. And even if you're called upon by your employer and you're dispatched, I wouldn't know for sure, but I'd be willing to bet that, because you can always quit at any time. That's the thing, right? Their slavery is illegal, right? So even if you're employed as a paramedic and dispatch calls you and be's like, you have to go to that job, and be like, nah, man, I quit. Right? You can't be enslaved, so why not? Probably, I would think. Now, once you start undertaking the duty, right? Once you start responding to it, you might have a problem, or you might at least have an obligation, but not in the first instance. Not in the first instance. You would lose your state license, but no criminal issue. That might well be true, Stephanie. Again, I can't speak to your state licensing issues. I can't speak to what your licensing issues are as a paramedic, or to what degree, if any, your licensing would require you to do anything. But there's no tort to you, right? They can't sue you. You may or may not have some disciplinary action under your license, but they can't sue you. They're not in privity, and you can't be criminally charged. It wouldn't make any sense. Yeah, so there are no more facts that could emerge that would bolster the claim. Plaintiff's failure to state a cause of action provides ample base to conclude they would not be able to add missing but required information to prove. An amendment would be futile and should be dismissed with prejudice. I think so. With a nurse, I might be criminally charged, not for failure to act. Not for mere failure to act. Mere failure to act? Because a nurse can always say, I quit. A doctor can always say, I quit. Right? You're not enslaved. So, you can always say, I quit. Mere failure to act, without obligation, cannot be a basis of some sort of criminal liability. It doesn't make any sense. Or even civil liability. It doesn't make sense. Again, once you start undertaking actions, you might have to follow them through. But if you refuse to act at all, I don't know, man. I'm not so sure. The plaintiff's allegations attempt to set forth a cause of action for intentional infliction of emotional distress, which requires you to do something, like pretty much every tort known to man. As an initial matter, the complaint's ambiguity and lack of separate statement and counts independently warrants dismissal for repleading. Well, we'd want more specific pleading, except, it doesn't make any sense. Defendants assume the cause of action is one for intentional infliction of emotional distress because words relevant to that cause of action appear in the complaint. However, the phrase intentional infliction of emotional distress appears nowhere in the complaint. It's also possible plaintiffs might be trying to allege a cause of action for tortious interference with a dead body, but that's not all clear. Again, to tortiously interfere would require you to do something. Stephanie says, if you start and then walk away, it's abandonment. Yes, correct, Stephanie. You're right. Yeah, you have zero duty if you're living a private life, right? If you start and then walk away, it's patient abandonment. But if I just see you in the street, there's no legal duty act. Correct. And it's completely the same for a civilian, incidentally. Nothing is magic about the paramedic in this example. So to go back to my example, right? To go back to my example of the lake. Let's suppose there's two of us there. Let's suppose there's two of us there, walking by the lake, and we could just throw the ring to you. And my friend next to me says, geez, I'm going to go throw the ring to him. And I say to him, don't worry about it. You can just go ahead and walk on ahead. I'll throw the ring to him. My friend says, okay. And then I proceed to not throw the ring. Now I have a problem, right? Because by saying I was going to undertake that action, and by taking away that rescuer who was going to do something based on my false representation, now I have a problem, right? So it's like, oh, I'm going to jump in and save him. Don't worry about it. I'm a trained rescue swimmer. I can do it. You know, you go and call 911. I'm going to go save him. And then I, don't. Yeah, then I as a civilian might have a problem. So there's nothing magic about the paramedic in this example, except, to the extent their licensure would be somehow implicated by them, undergoing and then stopping. But my tortious liability, and even potentially even criminal liability potentially, could pop in at that point because, I recklessly endangered by my actions by saying, don't worry, to him, don't worry, you go on ahead, I'll rescue him. That might be like some criminal negligence, but then again, I did something now, didn't I? I undertook some action, which in this case was making a representation. I got it. And you went on ahead and okay. So yeah, but my mere standing there isn't going to do anything. If I try to stop him from throwing the lifesaver to you, that could be a problem. If I try to talk him out of rescuing you, maybe. But my mere failure to do anything, no. This is why we have to understand these things with delineation, and why I speak with precision when I discuss these issues. And sometimes people don't understand the precision by which I speak. But my entire premise is, if you do nothing, right, there's no liability. And then, someone asked about the paramedic. I'm like, well, if the paramedic does nothing, and that's the entire premise, right? If they do nothing. But, once you do something, once you start undertaking the rescue, once you start responding to the call, once you radio dispatch, not screw you, I quit, but instead, responding to incident, once you do that, yeah, now you're in a whole different world picture, but you did something now, didn't you? So this is why we have to analyze these situations with precision and listen to words with precision, right? It's only in the failure to do anything that you're not going to run into problems. If you did something, we're in a whole different world of analysis. This is why it's important to be precise. It's also possible plaintiffs might be trying to allege a cause of tortious interference. And how? Because they didn't do anything. But it's not all clear. The Florida rules require that a plaintiff must state a cause of action, and if a complaint is so vague, indefinite, and ambiguous as to wholly state a cause of action, it should be dismissed. Plaintiff's complaint ambiguously draws language from two unidentified causes of action and does not identify either. Well, that is a bit of a problem. How do Good Samaritan laws nullify your argument? Good Samaritan laws, to the extent they exist, don't require people to act. The Good Samaritan laws I'm aware of provide a civil liability shield for action. So I'm not aware of any. That was the premise of that last episode of Seinfeld, was this affirmative duty to act. No, you can't do that. This is America, as Jackie Childs said, and Jackie Childs was right in the last episode of America. This is America. You don't have to do anything for anybody. Right. So if every Good Samaritan law I'm aware of on the books provides a civil liability shield for those who do act. So it provides you some tortious immunity for your actions, but it doesn't hold you liable for non-action. So, if there's a law out there that requires you to act, it's a non-starter. And even duty to inform law or requirements to inform, for mandatory reporters just have to report. They don't actually have to intervene, typically. So a mandatory reporter just has to report, and that's about it. But that's about as far as it goes. The complaint is further deficient because it names, by the way, I do appreciate your questions, and I hope I'm answering them with some precision. This is a great opportunity for us all to learn. And so I really thank you for your questions, and I thank you for the opportunity to clarify some of these areas, because I want everyone to understand what I am saying and what I'm not saying, right? What I am saying and what I'm not saying, so that you can apply these things correctly in your questions. Help me clarify this. So I appreciate it all. You're doing great. The complaint is further deficient because it names two plaintiffs and two defendants without attempting to distinguish. They offer no theory that would impute the conduct of one defendant against another, so any cause of action against them must be separate. That's not entirely true. There is a way to do this where you're not sure which of one of two people did it. There's a specific name for it, which I don't remember, but apparently near to the plaintiffs. So commingling various claims against all defendants may warrant dismissal. There is a way to do this where it's not that both people contributed. It's that, well, maybe that says, but one of the two did, and you're not sure which. There's a name for that in tort law, which I don't remember. But there's the thing. But they didn't bring it up, so, whatever. Similarly, each distinct plaintiff must maintain its own action to recover for its own loss. Fair enough. When the two pleading deficiencies require dismissal and could only potentially be corrected, yeah, these could be corrected, I'm sure. The legal theories are fatally flawed and could not be remedied. Yes, so we could attribute who was harmed by what more, but neither was harmed by anything that's legally cognizable. No, contributory negligence isn't the right idea. Contributory negligence is part of comparative negligence in terms of when a person who's been hurt themselves is part of the reason they were hurt, do they get to recover? And so contributory or comparative negligence is part of the theories of assigning responsibility to the defendant for part or all of the harm that befell them. That's where contributory and comparative negligence come into play. So good idea, but not the right one. Vicarious liability is not the right idea. Vicarious liability is where someone is responsible because of their relationship to somebody else. Most commonly in the case of a employer. So I'm responsible because they're responsible. Respondeat superior is an example of vicarious liability. The liability flows from one person to another because of some relationship between the two. So not the right theory, but if we keep poking at ideas, maybe we'll get there eventually. Pleadings must be something more than an ingenious academic exercise in the conceivable. Florida is a fact pleading jurisdiction. To withstand dismissal, plaintiff must allege more than naked legal conclusion. Okay, so we need more than notice, which incidentally, we didn't even have that. But yeah. To withstand dismissal, plaintiff must allege more than a naked legal conclusion. It's insufficient to plead opinions, theories, legal conclusions, or argument. The quality of pleading that's acceptable in federal court, and which will routinely survive a motion dismissed for failure to state a claim upon which relief may be granted, will commonly not approach the minimum pleading threshold required in state courts. Totally fair, right? Different courts require a different level of pleading. Like, how much stuff do you have to put into your complaint to make it pass go, right? Now, the federal courts don't require very much. Right? As Matthew pointed out, the Supreme Court did change it from the merely possible to the plausible. So it has to be a little bit more than theoretical, but not much, right? And you don't have to go into a lot of detail at all. The federal courts have what's called notice pleading. So you just have to basically say what they did. And it can be very, very bare bones indeed, right? Just the legal theory and just enough. Now, this is true, of course, in most of the time in federal court. There are a few exceptions. Right? Most notably, as we discussed recently, RICO, where they want you to be very fact specific because the courts hate it. But most of the time in federal court, you just have to do notice pleading. But then again, that is federal court. And of course, state courts differ. And apparently Florida does. They want a little bit more detail in their pleading in order to say, boo. Fine, no problem. Florida officially recognized the tort of intentional infliction of emotional distress in whatever in 1985, which also, incidentally, fair point, because tort, of course, is a matter of state law, and your state may not recognize certain torts and may recognize other torts that other states don't recognize. You know, well, my personal favorite tort that is not recognized by most states. I know it's recognized by North Carolina. And I think there might be one or two other states floating around, but it's not much. It's a small list, right? It's North Carolina and maybe two other states out of 50. But they have like my favorite tort ever that's not recognized by anyone else. Alienation of affection in marital relationships. It's the greatest thing ever. It's the greatest thing ever, right? I was cheated on. I'm married, and I was cheated on by another guy. Normally, I'm plumb out of luck. But in North Carolina, I can sue the other guy. I can sue the other guy for alienation of affection. My wife's affection was mine, and you took it away from me. And now you took it away from me improperly, and I'm going to sue you for alienation of affection. It's like my favorite thing ever. And it does pop up every once in a while, and it's great. So I was cheated on, but at least I get to sue the other guy into oblivion. Not recognized in most states, is recognized in North Carolina. It's my favorite obscure tort. It's my favorite obscure tort. Okay, to state a cause of action for the IIED, you must state deliberate or reckless infliction of the mental suffering, which requires you to do something, outrageous conduct, which requires you to do something, the conduct caused emotional distress, which requires you to do something, and the distress was severe. Yeah. It's also recognized in Illinois. I told you it was like floating around in like 2 or 3 states. I just didn't remember. So Illinois, sure, why not? Behavior claimed to constitute intentional infliction of emotional distress must be so outrageous in character and so extreme as to degree as to go beyond all possible bounds of decency. That too. It requires a lot, and it requires you to, do something. The sort of classic example of intentional infliction of emotional distress is going up to a young mother who has a young child, and as a matter of fact and reality, her child is safe. But you go up to her and you tell her child is dead, right? But for a fact that's not true. That's sort of your classic example of IAID. It's not that I was confused. It's not that I was, giving bad information. I know for a fact it's not true, and I'm still telling you anyway, just because I want to see you suffer. That would be kind of the IID. And it also gives you an example of the level of outrageousness we're kind of looking for. This is not mere insults. This is not Chris Rock made a mean joke about your wife being in G.I. Jane 2. It requires quite a bit more. In applying that standard, the subjective response of the person who's the target of actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. That's true, because maybe you're a pussy. Rather, the court must evaluate the conduct as objectively as possible to determine whether it's atrocious. Yes, so this has both an objective and subjective element. You must, in fact, have been damaged. So, if you're just a particularly resilient person, right? So it's not intentional infliction of emotional distress if you're not damaged. So if you're just like the most resilient mother ever, and someone comes up and says, hey, your kid is dead, and you're just like, well, that's unfortunate, then I guess it's not IID because you didn't respond. It might be objectively outrageous, but you're just kind of nonplussed about it, which is a weird take. But hey, we're just talking about law vacuum world. In a law vacuum world, if you're just like, okay, well, that's unfortunate. What do I do now? I guess there's no IED, so we need both the objective and the subjective. Even if the complaint alleges facts, if those facts must establish a cause of action. Yeah, you need to actually plead something that, makes sense. While the plaintiff alleges some facts, those facts could never establish IED because their actions were legally permissible, constitutionally protected, not outrageous, and do not give rise to cause of action. Yeah, keeping your damn mouth shut is an option. Shut the fuck up is an option. Now, whether or not you think the Laundries had any sort of moral duty or not is a position, I think, of division. Because I think actually this would be an interesting poll. And I'm going to make a poll as soon as I'm done talking, because I think this is an interesting question about whether or not you think Brian Laundrie. So let's assume for the sake of this argument, okay, let's assume that the Laundries know. Let's assume that Brian Laundrie told their mom and dad that they killed the fiance. Let's assume that he told them where the fiance's body was when that was still an open question. All right, so let's assume that they know that. It's like, Mom, Dad, I've got some bad news for you. As it turns out, I murdered my fiance. I killed her, and she's dead. And here's where the body can be found. Okay, so this is the hypothetical. Now, the police come / the parents come. Well, we'll make it the parents, make it a little bit easier for you guys. The parents come and say, we're really concerned about our daughter. Do you know anything? In this hypothetical, do the Laundrie's parents have a moral obligation? Now, I think it's an interesting question because obviously from the Petito's point of view, right, it would be probably nice to know where your daughter is when you're panicking and and have the truth come out and them tell you the things. But then, of course, from the Laundrie's point of view, they might want to protect their son. Now, in the last time I asked this question, some people were like, well, if it's my kid, I turn them in. I turn them in and I tell the things. But I'm interested to see if this is sort of the general consensus opinion. It's like, would you rat out your son to the parents / the police and let their consequences be? Or would you be like, well, I'm going to protect you to the maximum extent of the law? So what is the moral posture here is the question. So I guess the question is, were the Laundrie parents morally required, or I guess obligated, which is the same thing, to rat out their son? To anybody, to the police, to the Petitos, just to anybody, yes or no. I'm interested in what you have to say on this position. Also, by the way, you can assume in this hypothetical that the Laundries have no criminal exposure. So just additional fact, the Laundrie parents have no criminal exposure. I'm just telling you they have no criminal exposure. So it's the only criminal exposure is to their son, if any. They have no criminal exposure. So do they have a moral obligation to tell? Okay, great. Let's see what you guys say. Outrageousness is the threshold test for recovery in an intentional infliction of emotional distress. Whether conduct is outrageous enough to support such a claim is a question of law, not a fact. Correct. Right. Ultimately, the question is one of fact. Importantly, the standard for outrageous conduct is particularly high in Florida. It's particularly high everywhere. It's not enough that the defendant acted with an intent, which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even though the conduct can be characterized by malice or degree of aggravation, which would entice the plaintiff to punitive damages for another tort. Rather, the liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and regarded as atrocious and utterly intolerable in a civilized community. But Kurt, we don't really know that. But that's why it's my hypothetical law world. This is the wonderful thing about writing. This is the wonderful thing about writing law hypotheticals, Angel, because I just get to dictate reality. Right? That's the wonderful thing about law hypotheticals. I get to just declare they have no criminal liability for the purposes of the hypothetical. It's true because I say it's true. It's my hypothetical. It's nice. This is like what we do on bar exam questions, right? It's like, oh, I'm going to just declare reality. Oh, they have no criminal exposure. It's fine. They don't. Yeah, for the purposes of the hypothetical, sure. Generally, the cases in which the recitation of facts to an average member of the community would arouse his restatement against the actor and lead him to exclaim outrageous. The law is clear that a pleading is insufficient if it contains merely conclusions, as opposed to ultimate facts supporting each element of the cause of action. Although the complaint alleges that the Laundrie's conduct was outrageous, the complaint failure to provide factual supporting rising the level of outrageous conduct makes the allegation nothing more than a legal conclusion. I agree. The essential allegations against the defendants are nowhere close to meeting the necessary standard. Those allegations are, without providing any factual support, the complaints that it is believed that Brian Laundrie told his parents that he murdered Gabby Petito. Christopher and Roberta Laundrie spoke and hired an attorney on September the 2nd. There was no contact between the Laundries and Petito. The Laundries were on vacation from September 6th to 7th. Robert Laundrie blocked Schmidt on her cell phone and Facebook on the 10th. The Laundries' attorney made a statement on the 14th. The attorneys for Petito and Schmidt issued a letter to the Laundries on the 16th. The Laundries did not respond to Petito, Schmidt, or law enforcement. The Laundries instructed that all contact be made through an attorney who did not comment. The Laundries did not provide a whereabouts of Brian Laundrie, followed by unsupported allegation. The Laundries were making arrangements for Laundrie to leave the country, which is contradicted by the undisputed fact that he was deceased. Well, actually, strictly speaking, that doesn't contradict it. They would have to know that. Eddie Oliver says, even with no criminal exposure, you still remain silent. Look at the parents of the Michigan shooter. I don't think they did anything criminal, and they're still facing charges, just in my opinion. By the way, I'm back in Texas. Check your email. Thank you very much. I appreciate the chat. Yeah, I just wanted to eliminate problems. I'm just eliminating problems by saying there's no criminal exposure. So, don't fight the hypothetical. Don't fight the hypothetical, as they tell you when you're doing this for lawyer or doing this in court. Just take the hypothetical and roll. None of the allegations recited above, either alone or together, describe outrageous conduct. In fact, the complaint failed to allege conduct at all. Basically, the complaint alleges Laundrie failed to have any contact with the plaintiffs when they wanted them to speak. Yeah. That allegation falls so far below the particularly high standard for outrageous conduct, it should never have been filed. The only affirmative statements alleged in the complaint were made by the attorneys from Laundrie, which is entirely appropriate under the circumstances. Yeah. Seems to be a nice little division in the poll, 45-55 on yes versus no. Interesting division. So, a little less than half of you say route out, and a little more than half of you say no particular moral obligation. Interesting. I don't know what it says about me or my character, but I think maybe it's because I'm an attorney. But if my kid came to me, I think my first thought would be to, insulate them, to the extent that the law would allow. Eddie Oliver said, don't fight the hypothetical. I'm sure that's what they told the J6 defendants. Ha 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 ha. How old am I? Oh, well, first of all, you're very kind. But I'm currently dating somebody, but I am 41 years old. But thank you very much. The plaintiffs cannot express sympathy and understanding for the Laundrie's inevitable position and then claim the Laundries caused them emotional distress by not responding in the way plaintiffs desired. If the Laundries act of doing nothing other than maintaining privacy and silence, it's enough to subject them to the supposed cause of action. There be virtually no limitations on the tort of IID and the fundamental right of remain silent. Yeah, shut the fuck up has to be a legal option. That has to be a legal option. Stephanie says her dad would turn her ass in and then pay for the best criminal defense lawyer he could find. I don't know that those are necessarily mutually compatible objectives, but okay. Labeling the Laundrie's silence as outrageous is particularly incongruous with the context of attempting to contact the Laundries discussed in the complaint. The only attempt at contact alleged is the attorney for the plaintiffs issued a letter to Christopher and Roberta Laundrie asking for help in locating Petito. Because it would be a violation of the rules regarding Florida bar for a plaintiff's attorney to contact the Laundries, knowing the Laundries were represented, and sure would be, incidentally, that would be unethical. The plaintiff's attorney presumably did not send that letter directly to the Laundries. That would be a problem, right? If I know you're represented by another attorney, I cannot talk to your client directly. That's kind of, yeah. The complaint is not specific about how these letters were issued, whether through the mail or some other means. The complaint says nothing about whether Laundries actually received that letter, so their lack of response is a far cry from the outrageous conduct that goes beyond bounds of decency. Further, Laundries would not respond to communication that may or may not have violated the rules of professional conduct is hardly outrageous. I agree. I agree. Yeah. The nice thing is if my kids come to me, at least I can say, well, give me $1. So now that I'm your lawyer, so now I don't have to talk against you, right? Because typically there's no privilege between parent and child, right? So typically a parent would have to disclose what their child told them, but not if the child's my client. One of the side benefits of being a lawyer, right? It's like, what did your kid tell you? I'm sorry, it's privileged. Suck it. Ha 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 ha. Further, the intent element alleged is sufficient as a matter of law. The complaint accuses Laundrie of acting with malice or great indifference. Florida is clear that acting with malice or indifference is not enough. Outrageous conduct is what is required. No shit. Can I do that? Sure. There's no ethical requirement against representing my family. Sure, why not? That's fine. Spouses don't have to disclose what other spouses tell them. That's true. Yes, a spouse doesn't have to, well, except in New Mexico, which abolished this rule for reasons that pass all understanding. But yes, in like 49 states at least, a spouse does not have to testify against another spouse. So what my spouse told me is privileged, but not what my child told me. But I'm a lawyer. So I give my child, I say it's like, okay, well, now this is a legal consultation meeting. I'm now representing you pro bono. I'll write it up and put it in the file. Keep your mouth shut. Critic says, what's the difference? Why is it different for parents? That's just the law. I don't know what to tell you. It's just the law. I mean, for spousal privilege is a thing. Like one spouse does not have to testify against the other spouse. What my spouse tells me, they tell me in confidence. So if you ask me, like, what did your spouse tell you? I tell you, go to hell. It's privileged, right? What a kid tells a parent is not privileged. I guess the reason it's privileged in the marital context is like the sanctity of marriage and notions around that. But like, yeah, what your kids tell you is not normally secret, but I can make it secret because I'm a lawyer. That's the law. For kids, does it depend on age? Nope. Crime fraud exception. Crime fraud exception only applies for ongoing crime. Crime fraud exception does not apply to past acts. Only current or future acts, right? So the crime fraud exception to privilege. The crime fraud exception to privilege is the idea that the attorney themselves is involved in the crime or involved in the fraud, which of course is a crime, right? But that doesn't relate, that only relates to things that I was part of, right? And it would only, and in the crime fraud exception to privilege would only apply to future plans. So if I was part of the conspiracy, if I was part of the criminal conspiracy, privilege is dead, right? So yes, if the nature of the communication was in furtherance of a crime in and of itself, then privilege is dead. If what you're communicating to me is future crimes or future frauds, then privilege is dead. But if my kid comes to me and says, hey, I killed my fiance, those are things in the past. Presumably I didn't take part in this hypothetical. So I'm not part of the crime fraud. It's not an ongoing fraud because it's in the past. So the crime fraud exception isn't a problem either. So I should be fine. Yeah, you should be fine. At its core, the complaint is critical of Laundrie's for refusing to respond to either the Petitos or Schmidt or law enforcement. However, compelling individuals to respond to inquiry by private citizens or law enforcement through civil action like this would turn our entire constitutional and the freedom afforded individuals into the country on its head. The plaintiff's suit, founded on their thoughts or position of what they wanted the Laundries to do, infringes on too many rights to be discussed in this motion. But the exercise of even one is sufficient to defeat the claim. It sure is. D. Sewell says in Florida, it's legal for parents to aid and abet their kids. To a point, it's legal for parents to aid and abet their kids in Florida, up to class C felonies, which this was not. This exceeded those limitations. So yes, I don't think even in Florida this would fall under the exceptions for parents to aid and abet. But yeah, this is where people get into trouble because they'll hear something and they'll take it too far, right? Oh, in Florida, it's legal for kids to aid. It's legal for parents to aid and abet their crimes under very defined and limited scenarios. Yeah. From first recognition of the tort of intentional infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would be extreme and outrageous, may be privileged under some circumstances. The actor is never liable, for example, when he's done no more than insist upon his legal rights in a permissible way, even though he's well aware the insistence is certain to cause emotional distress. This principle is upheld many times. Apparently, this was an issue in a case in which a convenience store called the police to have a 6-year-old shoplifter arrested, and they claimed IIAD. But it was a 6-year-old, which, incidentally, I'm not even sure poses criminal liability for the 6-year-old because they're 6. But the store is still within their rights to call, about it. The Laundries had a legal right to do or not do everything described in the complaint. The Laundries are entitled to freedom of thought protected by the First Amendment, which includes both the right to speak freely and the right to remain from speaking at all. That is one of the virtues of the First Amendment. The First Amendment includes the freedom of speech, which of course includes the freedom to not speak. Yeah. And Mira is right to have accessory liability. You need to have some knowledge of the crime in some event. So yes, if you aid and abet, but without knowing there's criminal exposure, then, or without knowing there was a crime, then it's not aiding and abetting. You need to have some knowledge that they committed a crime. See, Susan says, I'm not sure if they're speaking to me. You speak like you don't know the law, so I presume you aren't an attorney. I am an attorney. Just a guy with opinion. I don't know who you're speaking about, Susan. I'm speaking with some definitiveness in some areas. Maybe you're not speaking to me. The Laundries have a general constitutional right not to speak on any topic, and a more specific constitutional right not to speak in the face of criminal investigation. There's unquestionably a law enforcement investigation of the Laundries regarding the disappearance of Petito, and the Laundries have and still have an absolute right to remain silent. For Laundries to exercise their right to remain from speaking and to instead hire an attorney to speak for them is not only common practice, but embodies the exercise of fundamental rights. It sure does, and they did the right thing in any event. You know, if here is a legal opinion for you. Here's a legal opinion for you. If your kid comes to you and says, "Hey, mom and dad, I killed my fiance," you probably should call a lawyer immediately. Both one for your kid and one for yourself would be recommended. There's some official legal advice. If your kid comes to you and says, "I murdered my fiance," hire a lawyer. And there's some legal advice for you for the day. Hiring a lawyer makes you look guilty. It might make you look guilty, but it'll go a long way to prevent you from being guilty. Right? It'll give you a long way to prevent you from being guilty. Sure, you can give a wrench out if you want, Stephanie. That's fine. I trust your judgment on such things. Hire a lawyer is always good legal advice. It's the safest legal advice I can give because it's the only legal advice it's the only legal advice that's explicitly recognized in the rules of ethics, right? It's the one piece of legal advice I'm always able to give. Hire a lawyer. Always able to give that legal advice. It's right in the code of ethics. It's great. Yeah, hiring a lawyer might make you look guilty, but it goes a long way to prevent you from being guilty. And we'd very much like you to prevent you from being guilty. So you might think the Laundries are guilty of something, but they didn't talk to the police, so they're not guilty of something. So shut the fuck up. Could I do a reading of the Constitution? Sure. Okay, both the United States Constitution and Florida Constitution indisputably permit retention of an attorney on occasion require the government to provide services. The citizen's right to consult an independent lawyer and retain that lawyer to speak on their behalf is an aspect of liberty that's priceless. Florida provides an even broader right to counsel than is provided in the Sixth Amendment. Yeah, fair enough. The right to effective assistance and counsel is guaranteed by the 6th and 14th Amendment, and Article 1, Section 16 of the Florida Constitution is immutable principles of justice. Yeah, it's always legal to hire an attorney. If the act of hiring an attorney provides legal exposure, I mean, come on. Incidentally, as I'm sure you noticed, we got the new tripod in. And it's a much better tripod than the one we had before. It's a much better tripod, a much better quality tripod. So yes, the tripod woes are over. And as you can see, even though the old tripod caused the camera to fall to ground, camera hit ground, camera go boom. Fortunately, the camera is still operating perfectly fine. So congratulations to Sony for making a decent camera. Less fortunately, the boom arm that I got really didn't suit my needs. But that's okay. The old boom arm is working great, even though it's a little cheap, but it functions. So the camera is on a much more stable tripod. The mic is on its old boom arm. The lighting is great. Everything is wonderful. There's privilege in Florida for parent-child. I doubt that. I mean, I wouldn't swear to it, but if we're taking bets, I bet there's not privilege for parent-child in Florida. You must say I exercise my right to remain silent. How's that work if you're mute? Write it down. Write it down. That'll be fine. Spell it out. Mouth it. I don't know. In addition to the Sixth Amendment right to counsel, there's also a long recognized First Amendment to right to hire and consult an attorney. Yeah. Along with the protections afforded by the First, Fifth, and Sixth Amendments, and similar provisions in the Florida Constitution, the Laundries also have federal and state constitutional protected privacy rights. The Due Process Clause of the 14th Amendment protects individuals from state intrusions on fundamental aspects of privacy. Put simply, the Laundries have a fundamental constitutional right to silence, privacy, and representation by counsel. But the Laundries' exercise of those rights is what claims them the emotional distress. That does seem to be the basis of the claim. 1999 from Eddie Oliver. Thank you for the super chat. Hey, Kurt, unrelated, but kind of related. Aren't most of you attorneys freaking out the government has been spying on attorney-client communications, like in the case of Project Veritas? Thinking about the Laundries. Yeah, the whole thing about Project Veritas is messed up on a whole number of levels. But the thing is, like, it's messed up. It's messed up, but they can't use that evidence in court. It's all privileged. So the fact they're spying on it is not great, but it's all still private. And yeah. And if you could prove it in a court of law, I think you would get dismissal because it was so outrageous. I think you might be able to even pass like independent means of construction because it's just so outrageous. The complaint suffers from another fatal flaw is further evidence as to why there's no cause of action. For conduct to be actionable, the conduct must be directed at the plaintiff and in his or her presence. As set forth in complaint, there was no contact between the Laundries and the plaintiff. If there's no conduct, they certainly could not have committed any conduct in the presence of the plaintiff that would support the cause of action. What happened to Ms. Petito is certainly unfortunate. However, as the Third District Court of Appeals reasoned, if courts were allowed relatives of torts victims compensation for distress they suffer when they receive bad news about family members, when there's no attendant, intentional, or reckless conduct directed towards them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim only in carefully prescribed circumstances. Is compensation permissible for relatives who suffer emotional distress? It's not lack of compassion, but necessity that restricts relief to immediate victims. Yeah. The last two elements necessary to state cause require factual supports that defendant outrageous conduct caused it. It's a little bit of a problem when how does the non-conduct, I asked the question, how does the non-conduct cause the emotional distress? And then I'm immediately reminded of how does the non-interstate non-commerce become interstate commerce? And I become sad inside. The plaintiffs all but concede the complaint that the Laundries did not cause grief. The complaint alleges Laundries knew of the mental suffering and anguish and knew they could alleviate it, at least in part. Such mental suffering and anguish by disclosing what they knew about the well-being and location of Petito. By setting forth the allegation they knew of mental suffering prior to an independent, the Laundries' conduct of remaining silent. That is a problem too. That's a problem too. Rather than alleging the Laundries were sole and proximate cause of distress, in essence, the plaintiffs alleged Laundrie's silence failed to alleviate the mental distress. Since alleviation can only come from suffering that's already being experienced, the Laundrie's failure to alleviate is not a proximate cause of injury. I mean, that too. Stated differently, the complaint's own allegations contradict the theory the Laundries caused the mental suffering and anguish. For the 253 of you who are here, thank you for being here. Thank you for being part of the Uncivil Law Army and being part of and if you'd like to be a formal uncivilian, you see these names on screen, the uncivilians at the top of your screen, and you say to yourself, geez, what is an uncivilian? How can I become an uncivilian, Kurt? I want to be one too. Well, it's not a problem, my friend. For a mere 99 cents a month, the least YouTube will let me charge you, you too can become an uncivilian. All you have to do is hit the join button or hit the link that Streamlabs occasionally tells you about. And if you do that, you get a little cool icon by your name, the little cool scales of justice, like A. Hedinger has, or Watching You Daily has, or God Guns Gains has, or ASP Atheist has, or Blue has. These are some of the wonderful people that have these icons, and you can have it too. Plus, you get your name on screen, and you help to support the channel. All those things. Thank you for becoming a member of the channel today. And also like, comment, subscribe, and all that stuff if you haven't done that already. $19.99, Eddie Oliver says, one last super chat before you cut out. How do you feel about some of these liberal justices that are becoming more activists in ruling, you mean, presumably, on the letter of the law? Yeah, I'm not a fan. I mean, no, it's up to Congress to pass laws and, yeah. Stated differently, the complaint's own allegations contradict the theory that the plaintiffs caused mental suffering and anguish. The complaint alleges the Laundries were the direct and proximate cause of plaintiff's injury and also alleges the plaintiff's grief was something caused by other than the Laundries' silence, which means both as a matter of law and fact, the complaint fails to allege the Laundries were a legal cause of the grief and the complaint should be dismissed. The pleader is bound by their own allegations in the complaint. In addition to lack of support for the causation element, the complaint does not allege, let alone factually support, the emotional distress was severe. The complaint spends most of the paragraphs discussing the Laundries and provides nothing beyond conclusory allegations of mental suffering and anguish by the plaintiffs. The term severe does not appear in the description of the alleged injury. While the complaint alleges plaintiffs were extremely distraught and desperately searching for information concerning their daughter, the complaint does not specifically discuss how plaintiffs' mental suffering meets the severity element, nor does it describe the element as severe. The fact remains, however, that significant feelings of fright, shame, worry, and humiliation, and others besides, occasioned by an act are, even if regrettable, an unfortunate part of living in society. Thus, courts that have tackled the issue have recognized a high standard for determining what kind of emotional distress is redeemable in a claim for intentional infliction to necessarily prevent the tort from becoming a venue for litigation over every emotional injury. And how. Oh, thank you, Rachel. That's very kind of you. In sum, the plaintiffs have failed to satisfy the elements of causation and severity. The plaintiffs were understandably fearful about what happened to their daughter, and they would have been upset about their daughter regardless of anything the Laundries could have said. I mean, that's true too. But that fear or sadness was not caused by the Laundries. It was an unfortunate, unavoidable part of the entire circumstances caused by Brian Laundrie and Gabby Petito. Yeah, I mean, yeah, this is right on the money. This is right on the money. So I think a dismissal's coming because they didn't do nothing. So, I mean, you can't sue them for the nothing. You know, you might want to get to discovery. You might really want to be able to get them on the stand and like make them answer about what they knew and when, but you know, you can't get that far. You don't have enough. And you know why you don't have anything? Because the Laundries hired a lawyer. They hired a lawyer immediately. And they listened to their lawyer. And they told all communication to go through the lawyer. That is why they are in the position they're in. Right? If they had talked to the press, if they had talked to the Petitos, if they'd opened their mouth, they would not be in the position they are. But they shut the fuck up. And they made the lives of their attorneys so much easier for it. $5 from AD. When a court writes an opinion, who researches the cases to include? The judge or the paralegal? It depends on the arrangement in... Stephanie, if there's another story you want me to cover, I'm open to it. I could take a quick break, and if there's another story, the chat seems happy. I'm on board for staying on. Stephanie, if you think there's another story for me to do, I'm happy to do another one. I could get a quick drink while we take a break and we do another story. That'd be fun. But yeah, just shut the fuck up. That's why they're in the position they are today. And it's a large position of why Redonda Vaught is in the position she is in today. Because she said, yes, please, I'd like to talk to you, investigator, for the next hour and 50 minutes. And then we just collectively held our hands and our head in our hands as we listened to the tape. Oh, you were asking about the paralegal thing. It depends on the court. It depends on the court and how the judge likes to operate. It totally depends. Some courts, some judges like to write things and have their paralegals clean it up. Some judges like to have their paralegals write everything. Sometimes it depends on the nature of the case. So the judge will take some things and like things that are not as important to let the paralegal write, or vice versa. Because they want the paralegal to spend more time on it. So sometimes the judge handles the not routine things and lets the paralegal handle the routine, or sometimes it's the opposite of that, or sometimes the paralegal does everything, or sometimes the judge does everything. It just totally depends on the court. It just totally depends on the relationship of the court and how they like to do business. Some judges are more hands-on than others, in terms of what they do. But yeah. So I'll let you guys talk amongst yourselves for a minute while I get a drink, and we'll stay on and we'll do another story. That'll be fun, and we'll see what else there is to do. So we're having fun. We're having fun in the chat. I'm in a good mood. My Tripod is here and doing its tripod thing, is full of tripod glory. Melanie, who talked to the detectives and F themselves? That would be Redonda Vaught, the nurse in Tennessee. So I'm going to get a drink. You guys talk amongst yourselves, and I will be right back with another story. All right, we're back. We are back. Hope everyone's having a great evening. I'm in good spirits. It's always nice when you're having an up day, you know? It's always nice when you're having an up day. Not every day can be an up day. Man, we will take them where we can. We will take them where we can. All right. All right, so we're going to read about two things, I think, for tonight and just try to comment on them a little bit and see what's going on. And we'll chill. And you got questions, you can super chat some questions and stuff. Feel good today. Okay, so there's this Dr. Hulsel trial. This case has been going on for a while. This doctor is accused of murdering like 14 people or something, giving them fentanyl and stuff. So, Trish wants to know, what about the drawing? I don't know. Maybe if you guys are good. I don't know. Maybe we should set a super chat amount. Let's see. I think we need another $100 in super chats before we can see the drawing. I think that's a good number. I am not beyond grift. All right. The murder trial against former Mount Carmel West Dr. Hulsel is scheduled to begin its 5th week of testimony. That is a lot of testimony, man. 5 weeks of testimony. Holy shit. 40 witnesses have taken the stand this far. That's a lot. Who has pled not guilty to the murder charges and deaths of 14 patients who were under his care at former Mount Carmel West from 2015 to 2018. I mean, no wonder it's taking so long trying to unpack all that, but still, man. Oof. The 4th week of testimony was the emotional trial this far. Several family members of some of the patients testified. And perhaps the week's most emotional testimony, Lynn Marshall, brother of James Timmons, 39, who died under Hulsel's care in 2018, testified he was crying ecstatically while he visited his brother in the ICU. Marshall said Carmel staff flip-flopped in their assessment of Timmons, who arrived at the hospital suffering from compartment syndrome, which Dr. Wesley Eiley said in earlier testimony deprives blood flow to the body's muscles. That's not the one that, like, no, that's lock-in syndrome. If I ever get lock-in syndrome, just shoot me in the head. I mean, seriously. When Marshall first arrived, he's told the nurse he could return to West Virginia home that night, as Timmons would likely recover. Later that evening, a different nurse told him the opposite, that he shouldn't go far because his brother wasn't going to make it through the night. Well, I mean, things do change sometimes in medical environments. Is this a drawing for your dragon painting? Oh, no, no, no. It's much more intense than that. It's Pepe the Frog's ass, but Uncivil Law. Yeah, it's much more intense than that. Locked in syndrome, not Loch Ness syndrome. Locked in syndrome. That's where you can't move, but you're still fully conscious. Yeah. You can't move, you can't speak, but you're fully conscious. I'd rather die. I would rather die. A Hanger says they can now give you a brain implant so you can request tool. I saw that. I'd still rather die. Yeah, internet commentator says it came up in the bar. Yeah, I know. It came up in the bar. I just can't remember what it was called. Yeah. Marshall refused on 3 separate occasions to change his brother code status to do not resuscitate. I told him to save him, I would not give a DNR. I understand that. I understand that. Despite initial reluctance, Marshall eventually agreed to change his brother code status. As he said, nurses made it seem as though he had no other option but remove his brother from life support. Well, if you knew he could say no 3 times, then, I mean, you keep going on. Family members weren't the only one to take the stand this week. Several of Hussel's former colleagues also testified. Several of those current and former nurses testified that their intent in administering the doses of fentanyl ordered by Hussel was to prevent the patients from feeling pain as they were extubated. What is extubated? That word is outside my vocabulary. What is extubated? Former ICU nurse Jamie Brooke, who administered a 1-gram dose of fentanyl to one of the patients, testified that Hussel was very caring and an amazing doctor who saved that woman's life when he urged family members to bring her to the ICU. Taking off the breathing tube pulled out. Okay. Extubated. Okay, I mean, so they're extubed. They're just extubed. Okay. The opposite of intubated. Well, yeah, I guess I probably should have figured that out, but because I know what intubated means, but I should have figured out that extubated would just be the opposite of that, but didn't occur to me. So my Latin failed me on that one. Brooks said she administered fentanyl because she anticipated the palliative extubation to be incredibly distressing and horrible for the woman. My intent was she would not feel her suffocate to death when she was removed from the ventilator. I mean, that sounds pretty reasonable to my mind. Several other former nurses, including Wesley Black, Jordan Breyer, and Kathleen McDowell, all testified they received no formal training on proper narcotics dosing, including fentanyl. ICU nurses received no training on narcotics? That seems odd. Doesn't it strike you as odd that ICU nurses received no formal training on narcotics dosing? I mean, I would think that would come up. The 3 also spoke about Hussel's admirable reputation in Mount Carmel, where he's known for teaching and mentoring other staff members in a way to improve care. During opening statement, Hussel's defense team put forth the doctors providing comfort care to patients who are reaching the end of their lives. I mean, I don't know. I have no particular position on this. I don't know. Maybe he's an angel of death. And maybe he's just administering a pain medication as they're reaching the last moments of their life. I don't know. I didn't say nurses could prescribe narcotics, but to have, because that wasn't what they said. The nurses that they could prescribe it. What they said, at least, was they received no training on it. Yeah. All testified they received no formal training on proper narcotics dosing, including fentanyl. Yeah, I didn't say the nurses could prescribe it, but to say they have no formal training on proper dosing, that seems odd. I mean, you would think that they would know what a proper dosing is. So they would know if a doctor orders an amount that doesn't make sense to double check. Right? Because doctors can make mistakes. You would think the nurses would have some training on what the proper amount of the narcotics is. Geez, doctor, it seems like you ordered 100 grams. Are you sure you need that much? The 100 grams? Don't want to double check that one with 100 grams? Seems like the kind of thing a nurse would have some training on. Didn't say they could prescribe it. Did say that they should have some training on it. Seemed like the kind of thing they might want to know. Seems like the kind of thing that might come up in the ICU nursing. I assume nurses are just not machines, and they'd be like, okay, 10 kilograms of the fentanyl. Okay, that seems like a good number. Open up as I shove it into every orifice of your body. That's a doctor's job. Some nurses know more. It depends. My generalized understanding, and I could be wrong, but my generalized understanding is that the nurses of ICU know quite a lot, and in some cases know more than doctors know. From practical experience. So I don't know, man. Nurses are trained to follow the doctor's orders. They're not trained to be idiots, though, right? I mean, a nurse will double check a doctor if it doesn't make sense, I assume. Because, like, you know, it's like, are you sure you wanted to prescribe? Really? You want to give them all these? Where am I supposed to shove 100 kilograms of drugs in this body? I don't know, right? I mean, I assume the nurses have some training of some variety, so they know whether or not the doctor has, you know, gone crazy or whether or not it makes any sense. But that's just what I assume. All right, we have another article. We can do Ask Me Anything. Ask Me Anything. For a $2 super chat, we won't make it expensive because $2 is the least amount that you can pay to ask something. But for a $2 super chat, I will ask any question you have. Okay, I will maybe ask any answer you have. Damn. All right. Let me readjust this article because we're going to talk about some horse thing. It's not ivermectin, some other horse thing. All right, let's see what we got here. Let's see what we got. Ex-Olympian accused of shooting woman at horse farm heads to trial for attempted murder. That's just a really cool title. I mean, you know, I just think that's a lot of cool. That's a lot of cool stuff, man. You know, that's cool. Ex-Olympian accused of shooting woman at a horse farm. I mean, that's just the greatest story ever, man. A former Olympian accused of shooting an up-and-coming dressage rider. The fact that dressage is an Olympic sport is the weirdest thing I ever heard of in my life. We should watch some dressage together. It's fancy horse tapping. It's horse prancing. It's a fucking Olympic sport. The fact that it's an Olympic sport is ridiculous. We should watch some dressage together. We're going to watch some dressage together because it's ridiculous. It's ridiculous. It's an Olympic sport. Michael Barosini, 57, the owner of Long Valley Equestrian Center, is accused of shooting trainee Lauren Kantrick twice in the chest following months of disputes between the two and attempting to shoot her fiance. Well, he's not very good at it, though. He should try harder. Kantrick, 41, and the fiance, 45, lived in a house on Barrowstone's farm at the time of shooting. Officials have said the couple were engaged in a landlord-tenant dispute with Barosini, who had agreed to Kantrick live at the farm when she trained under Barosini. But the relationship soured, leading to the shooting, officials said. At least 6 911 calls were placed from the farm in the week preceding the shooting. $2 from AD. Will an attorney go with me to the questioning? Will an attorney go with client? Will an attorney go with client to questioning? Sure. I'm here. I'm taking my life back, Barosini told the dispatcher during an August the 4th call. The shooting happened at the home of the dressage farm. This doesn't surprise me, but this is the first time I'm hearing this information. There are farms specifically for dressage. That's like, wow. Kanaric and Besroni were having a discussion outside the home on the property when Besroni shot her in the chest. Try harder. I mean, try harder. 2 in the chest, 1 in the head, right? Or the other way around, man. I mean, come on. Barosini is accused of attempting to shoot Goodwin, but missed. Goodwin that tackled Baroni, breaking his arm in the process, charging documents say. Baroni was still pinned to the ground when the police arrived. I had a good life. Barosini told the police as he's being arrested, charged documents say. Well, caught in the act, as it were, not going very well for him. Karenik suffered serious injuries to her lung and ultimately went multiple surgeries. Basaroni was a member of the 2008 Olympic equestrian team that competed in Beijing and coached a rider who won the bronze medal in Rio. Lawyers on both sides have painted a protracted struggle between the two, with each side claiming harassment of the others. Lawyers for Basaroni have said in court that Kasendrick harassed him and his family daily, refusing to move out of his home when asked, making him fear for his safety, which totally justifies shooting somebody twice in the chest, by the way. You're hoping the horse was a shooter? The way the dressage goes, who knows? You had to Google dressage. Now you know, right? It's just fancy horse prancing. It's bullshit. It's a fucking Olympic sport. How is this an Olympic sport? How are the athletes is the question of dressage. In a civil suit filed by Kendrick, her lawyer said Basroni had harassed her for months. We could cover the civil suit. That might be fun. What do we think? Do we want to cover the civil suit of this thing? So we'll end this poll, by the way, on the should we turn him in? And we're evenly split on the morals of it, by the way, which is pretty interesting. Were the Laundrie's parents morally obligated to route their son? No, 51, yes, 48. Basically evenly split. Interesting. But is there an interest in us? Well, let Stephanie decide. Dressage is beautiful, takes a lot of training. Well, let Stephanie decide. Is this a case worthy of our analysis? Because it could be fun getting into the lawsuit on the dressage bullshit. Michael Barasoni shot my client point blank and intended to kill her. He should be convicted and put away for life. He is totally guilty. I mean, he's so guilty. He is absolutely incredibly guilty. He was still pinned by one of the alleged victims when the police arrived. And I mean, he obviously shot them. I mean, he's so incredibly guilty. The article is biased towards the guy. It would have to be a fuck ton of bias, Dirk. It would have to be incredible bias for this. I mean, for him to, he shot them, right? It would have to be a lot of bias, man. It would have to be a lot of bias. Let's watch some dressage, because that sounds like some bullshit that's worthy of our time. All right, we're watching some dressage now. Hold on.
Hello and welcome to...
I'll turn off. Let's watch some dressage. Oh yeah, look at the hands. Look at this. This is dressage. We got some fancy horse prancing. Look at this fancy horse, but this is dressage. This is a fucking Olympic event here with a horse prancing. Look at this bullshit. Are you seeing this bullshit? Look at this crap. Look at this. Look at this. Fancy, oh my god, slow motion prancing. Oh my god. It's a fucking Olympic sport. Who supports this? Look at the jockey, man. Look how excited they are about their fucking horse. Like they're responsible for this bullshit in some way. Oh yeah. Oh yeah. No, this is I'm feeling that Olympic spirit, man. I'm feeling it right over here with the dressage. Dressage me. Dressage me for days. Milk me in the dressage. Prance me. Prance me harder, baby. Gallop for me. Gallop like you mean it. This is an Olympic sport. Oh yeah, that's what I like. Oh yeah, give me that slow prancy. Oh yeah, slow prancy time. Oh yeah. That's what I'm in it for, man. Oh yeah. Woof. Woof. Prancing. Our culture is dead. Our culture is dead. Trish says it's about the perfect lines of horse. Really and truly, a lot of work goes into it. I mean, I'll tell you, man. It's just like, you know. Joke's on you, this shit's English. I have no problem believing it's English. I mean, that screams English to me. I mean, I believe that, man. Lots of money. I believe that. Should we watch some more dressage? I think we should watch more dressage. I don't think we've fully appreciated the dressage yet. I think we've only begun to experience the dressage, and really, I've come to a very sort of unfair conclusion, and we should watch more dressage to tell me how I'm wrong. Here's some more dressage. I've declared myself a judge of dressage, and let me tell you, this is just the best dressage I've ever seen. Look at that! Look at this beautiful horse and the hooves, and just prancing and a little bit hopping, and oh look, they're doing this little sideways shuffle. Little sideways shuffle there. Another sideways shuffle. There's absolutely no sense in which this horse has been abused in any way. I can totally tell this is what horses were made for, man. This is definitely what the horse would be doing in its natural state, man. It has in no way been through years and years of abuse, been throttled into this fucking prancing bullshit that somehow is an Olympic sport. Uncivil Law has decided that he's quitting his job and going as a professional dressage guy. I'm going to be the best dressage guy ever. I'm 41, I'm out of shape, I'm overweight, and I'm going to be the best dressage master that's ever been. I'm going to be the very best, like no one ever was. I'm gonna prance like no one ever did. Get my horse to do my bidding is my cause. Dressage master! I can beat that. I can make a horse do better than that. They'll never see a horse like mine. I'm gonna make a horse get on its ass and put its legs up in the air. Oh yeah, look at that prancing, man. Oh yeah, look at that coordinated prancing. Oh yeah. Oh yeah, man. I just orgasmed. This is bullshit. This is bullshit. Who does this? I don't know what to tell you, man. This is a thing, man. Well, my friends, I feel like we've come to a good place in the stream. Do you have any brony tattoos? I could get one though. Yeah, I could do something. Yeah. If you've liked the stream, please remember to like, comment, subscribe, all the rest of it. Do the YouTubey things. I'm gonna sign off for now until. Oh no, Trish wants to say see the drawing. I don't know, man. You want to see the drawing? I don't know, Trish. I don't know. I feel like I should hold the drawing in reserve. This chat didn't feel fully committed. I mean, I wasn't getting the fully committing thing. I think I'll hold in reserve for a future chat where people really want to commit. But till later, my friends. Until later. I've been Uncivil Law. Peace. Good night.